our Dean and President, Tom McHenry, will introduce our special guest.
Don't worry, I'll be quick. It's a wonderful pleasure to have T.J. Donovan back here at the school. He's been here before, a number of you have heard from him before. But before I introduce him, I'll just comment that it would be unfortunate not to have an SBA meeting in which we can discuss parking or dog policies or smoking policies. So I'm delighted that we're covering those things. It's a reminder of our close-knit community, but also our obligations to others. So I know that the town really appreciates the attention to the parking restrictions also. I hear that regularly from the members of the select board, as you can imagine. I've had a wonderful day today because in the space of 20 minutes, I have introduced the Chief Justice of the Vermont Supreme Court and the Attorney General for the state of California. As students at Vermont Law School, there is no other law school in the United States, I think, in which you would have the pleasure of hearing from the Attorney General and the Chief Justice within the space of an hour. So it's a wonderful sign, not only of the size of our state, but the strong sense of community in the state of Vermont. And I will allow someone else to tell TJ about why Justice Driver says Vermonters are like beluga whales. Something about hunting together and rubbing up next to each other. Anyway, TJ grew up in Burlington. He went to Merrimack College for his undergraduate degree, and we are going to eventually forgive him for going to Suffolk Law School and not instead of Vermont Law School. He came back to Vermont, was elected in Chittenden County, which is where Burlington is, where he was state's attorney for 10 years before becoming an attorney general. The one thing I want to mention is the extremely heartfelt and thoughtful talk he gave here several months ago when he talked about his own personal brush with the criminal justice system when he was quite a bit younger, and how much that taught him about both the criminal justice system, but about how it doesn't treat everybody fairly, because if you go in with a big assist, you often coming out much better, and that's not true for everyone. I know one of his great commitments in Vermont is achieving strong justice for all, and so we are delighted to welcome him here. You have the floor, Mr. Donovan. Thank you.
Dean, thank you for those kind remarks. I'm happy to be here today. Kyle, I really enjoyed your speech, but I have one request. Wait a few years before you run for Vermont Attorney General. That was a great speech. That was a great speech. I'm happy to be here, and I'm happy to talk to y'all. How much time do I have? 2 o'clock?
No, not yet.
Well, I'll say a few words and let's just open it 20 minutes and we'll open it up for questions, and I'm happy to answer any questions you may have. Look, you guys know as well as I do that we are in an incredibly unique time in our history as a country. And we are in an incredibly unique time for the role of attorneys to play in our country and in the defense of our country and the institutions of our country and the rule of law which this country is founded on. You know, the dean was kind to give a bit of my background. You know, I was a decent student growing up. Struggled a little bit of math, but I loved history, and I loved current events, and I loved reading about history and historical figures, and these stories of courage and overcoming adversity throughout our nation's history. And my own educational experience was the longer I stayed in school, from high school to college to law school, I did better academically because I actually found something that I was finally really interested in, of course, which was the law. Because for me, it kind of brought everything in together. It's the great history of the law, the evolution of the law, and the power of the law. And the power of the law to change policies, to impact people's lives, and to improve our community. And I think what happened on in November of 2016, and then on January 20th, 2017, everything that I think this country has fought for, and we are not as Lincoln would say, a perfect union. We are an imperfect union, striving for that perfection, really was at risk. And that was a shock to the system. And I remember when I was sworn in about, I think, January 5th on 2017. Of course, President Trump took office on January 20th. And I remember from January 5th to January 20th talking about how hyper-focused I wanted to be on Vermont and on local issues and on improving people's lives here in our state. Because in my view, it's the little things that are going to change and improve people's lives. And then January 20th came. And then January 27th came. And January 27th, I think, was the date of President Trump's first executive order, the travel ban. And here's the thing you got to realize about what was happening in January 2017, at least in the Attorney General's office in Vermont, and I would dare say in many Attorney General's office throughout this country, particularly those who had a Democrat elected. Everybody was getting a crash course in constitutional law. Nobody was practicing constitutional law prior to January 20th, 2017. But this is the amazing thing that has happened over these last 2 years, and lawyers have led on it, is this country has had one big civics lesson. This country has had one big conversation about the strength of our Constitution, about the strength of our institutions, and that is a good thing, in my opinion. I would submit that our citizenry is more informed and educated about the power of the law, the role lawyers play, our institutions, including that independent judiciary, than they have ever before, because those very institutions, those very principles are at risk right now. You know, when I was younger and you heard the word federalism, when I was in law school, it always kind of took on this Republican tone, if you will, that it was the federal government can't tell us what to do. Can't tell us states what to do to regulate how we live or what we do with our people in our state. And this was a great debate, and of course, you know as well as I do, because of that, we had the pushback from the federal government, and Lyndon Johnson signing the first Civil Rights Act in 1965, the Voting Rights Act, really that pushed back against states abdicating their responsibility to equal justice and equal protection under the law. But what you have today is a new federalism, where states have said simply this: federal government, when you step back and don't protect our environment, don't protect our people, don't protect the health, safety, and welfare of the American people, you are going to see states step up through their attorneys generals and protect not only our environment, the civil rights of people, the safety of people, the consumer protection issues that are running rampant. And that is what's happening across this country today in terms of the role of the Attorney General. And when you think about it, it has been an amazing 2 years, whether it's been on the environmental protection front. And here's the thing, I want to talk to you guys very personally. If there's any of you who perhaps may do well in some classes and may struggle in others, that's fine. I was a criminal prosecutor, which is a great job, by the way. If anybody of you want a great job, be a prosecutor. You want to change people's lives, be a prosecutor. You have an enormous amount of responsibility and an awesome amount of power to do good in your community. But people said, well, how's Donovan going to do when it comes to environmental law? And I know I'm talking at Vermont Law School, and there's a lot of environmental lawyers here. As the dean knows, there's a lot of acronyms in environmental law. It makes me nervous because I can't keep track of them all. And again, in January of 2017, you saw an absolute dismantling of the EPA. And Vermont has always had a proud tradition of protecting our environment and standing up for environmental protection. And I can tell you guys, it was easy for me. You know why? Because it comes down to values. Do you believe in clean water? Do you believe in clean air? Do you believe in being a good steward of our land? Those are universal values that are embedded in the law. And when these questions come up about dismantling the EPA or making sure that we get that the EPA tries to get rid of vehicle emission standards, these are easy legal questions to say, of course we're going to take a stand. That our values are going to dictate where we end up on an issue, that we do protect people's rights to clean air and to clean water. When it comes to the issues of civil rights, it was an easy decision to get involved and oppose what I still believe the president's unconstitutional order to ban people from certain countries. It was an easy decision to oppose the president's order on DACA. I gotta tell you, what was amazing to me was the criticism I would receive in taking those positions. On DACA, the deferred arrivals of childhood arrivals. People said, well, we don't have any in Vermont. Of course we do. But here's the thing. In fact, we have 44. That even if we had one, we would stand up and protect them. Because I believe what is most at stake right now in our country is our moral standing as a beacon of hope, as a beacon of fairness, as a beacon of goodness that the rest of the world looks towards. And that we have to defend our principles, we have to defend our values and our traditions and our rule of law, which is all predicated on the rule of law, through our institutions and through an independent judiciary. That when we talk about the rhetoric in the political environment right now, in that political arena, it gets heated. People are angry. But we don't do what perhaps our commander-in-chief has done, which is to tear people down based on their race, which is to divide people based on their gender, which is to separate people based on their religion and their ethnicity. That is inherently un-American. That when we challenge those policies, we do it through the court of law. That we file a lawsuit and go to the court. And if we lose, we appeal it. Because that is what the rule of law allows and dictates. That we don't espouse violence. That we don't take matters into our own hands. That as officers of the court, and soon to be of the court, that we adhere to those principles of fairness, of equality, of integrity, and the credibility of our system. The credibility of our system. When you attack judges because of their ethnicity, that's an attack on our institutions. When you blatantly flout our laws as the highest elected official in this land and don't believe you're accountable to it, that is an attack on our rule of law. It's not what's being said in the media. It is going to the very basic foundation of what this country was founded on. 3 separately equal branches of government. A system that, yes, has struggled to address equality, has struggled to address the issue of race, has struggled to address the issue of discrimination. But a system that is imperfect, but is far better than any other. And I say this to each of you as soon-to-be lawyers, soon-to-be officers of the court, that it's easy to get online. It's easy to express your outrage. And feel free to do that. But when you are an attorney, when you are that lawyer, particularly representing a state, you got a higher duty to make the tough decisions, to understand that there are larger issues at play, that the credibility and the integrity of our judicial system, that all people should believe in. Because the Constitution protects all of us. And if it doesn't protect all of us, it protects none of us. And that is an issue that inevitably, if you go into the public sector, which I hope you do, and I hope it's all in Vermont, because we need good people like you are going to confront. I addressed that issue on a very controversial case arising out of Bennington that dealt with former state representative Kiah Morris. She had received racial harassment online. I condemn it. It was demeaning, it was racist, it was derogatory, it was wrong. And it went to the police. And I want to address this issue. I may be to go longer than 20 minutes, but this is incredibly important. When you are in government, that integrity and the belief that government works for everybody is incredibly important, because perception matters. And when people don't feel that government hears them or listens to them or responds to them, this is a major problem. And when you talk about the role, or I should say the office of government that most people have contact with, it's with the police. Because you're going to call the police when something goes bad. But what we can't do is erase the historical legacy of racism when it comes to law enforcement. And that historical trauma. And whether it was in this state or in other states throughout this country, law enforcement has a terrible track record of dealing with the issue of race. And the numbers bear that out nationally. The numbers bear that out here in Vermont. Our incarcerated population should be a reflection of our general population. And our general population, people of color, African Americans, make up maybe 2%. That might be high. In our jails, it's close to 10%. We have to acknowledge that racism is real. And in Bennington, on that issue of public safety and perception, that when you call the police, when I call the police, I expect that they're going to come to my door and I'm going to talk to them and they're going to validate my feelings. They're going to make me feel safe, because that's how we believe the system should work. The fundamental failure in Bennington County was a lack of response from local government. Validating fears, listening, and making sure that people felt safe. Put the legal system to the side and talk about how people interact with our local government. It's often through the police. And the work that we need to do on the issue of training, the issue of cultural competency, to understand that historical legacy of racism, is work that I'm committed to, is work that's long overdue, is work that we need you involved in, and particularly white guys in power. We have to do one simple thing. We need to listen. We need to listen. And acknowledge that our experience is different. Because I just acknowledged my privilege when I said, I expect them to come to my door. I expect them to listen to me. I expect them to validate my experience. I expect to feel safe. That is not a universal experience, and that's the problem in this system. I don't believe it's malicious or intentional, but it is that blatant, insidious form of racism that we have to address in this country, in this state. And when that process did not work locally, and keep in mind we got 14 elected state's attorneys in our 14 different counties. We do local control in this state when it comes to criminal justice. It came to the AG's office, and it came as a result for those who still want to get into criminal justice after this speech, as a form of a demand for a forensic examination, because most crime is now going to be done digitally, and those investigations are going to require forensic examinations. And the local folks did not have the capability to do it. And we came because there was an allegation of a death threat. Because when you're talking about speech and crime, in Vermont, you're now looking at a crime called criminal threatening. And if you're talking about a communication, whether you call it a threat, whether you call it a statement, or whether you call it mere words, you're also going to be looking at the First Amendment. So we got involved. We got this Vermont State Police involved. The Vermont State Police has a great team of forensic examiners. They did the exam on the computer where the alleged death threat came from. And it turned out that there was no death threat. That the threat that was showing up on the computer they had bought was a used computer. The family had bought the computer recently, and the former owner's 10-year-old son had a screen name that was dead. And it will still sync through the cloud, and that would pop up on the screen. That wasn't a death threat. But we said, well, we better look at this other stuff that's going on. There were allegations of burglary 2 years prior. There was an allegation that a GPS was stolen from a car, and there was an allegation that a tree had a swastika marked on it. We looked at it. The tree was close to a half mile away from their property. It was not their tree, it was not on their property, therefore it was not a crime. And there was no evidence that the swastika was directed towards them, and in fact had been there for quite some time. The burglary, there was no corroborating evidence. There was no eyewitness accounts. And this was 2 years prior, and you can't go back and say, go do a sweep for DNA or whether or not there was surveillance video. It did not exist. That was an easy call to say it wasn't a crime. Same with the GPS. And then it came down to online statements on a public domain, Twitter. And the facts that Ms. Morris at the time was a state representative is an important fact. Because when you look at the First Amendment, and when you look at protected speech, it's a high bar, because the courts have been very clear. This democracy flourishes when dialogue is open, even when it's violent, even when it's caustic. Because this democracy is far from perfect. In fact, it's messy. And the statements, as I said, were racist and demeaning and derogatory. And our questions as lawyers, and personally offended me. Personally offended me. And I like Kiah. Kiah's a friend of mine. I care about her. I felt terrible for her. But here's the question to you, as that future public official. Do you go by your feelings or do you go by the law? Do you go by your emotions or do you go by the facts? It's an easy answer. If you're going to do the job with integrity. So let's look at the facts. First one was Twitter essentially mocking the African American dialect. Not a threat, racist and demeaning. I condemn it, but not a threat. Because our job is not to say this is hate speech. Our job is to ask, was a crime committed? No. And as you all know, well, what's the law? What's criminal threatening mean? What's the rule? Well, the rule is very clear. The rule is it has to be an explicit threat of harm. And if I can recall the case, which I believe I could, Virginia v. Black, don't quote me on this, but you guys can probably Google this. It was a serious intention of placing a person in fear of death or serious bodily injury. Death or serious bodily injury. That explicitness of the harm. I want to tag that reasonable person standard because I think that's something we have to talk about. Second threat, second statement, was mocking essentially an African American woman's hairstyle, in which Twitter was directed towards a reporter at the time for WCAX who was African American, and Ms. Morris was tagged on it. Not an explicit threat of harm. Again, racist, demeaning, derogatory, insulting. And these were occurring during an election season in 2016, the months of October of 2016 up until November of 2016. Our investigation is in 2018. In December of 16, Ms. Morris gets essentially a civil restraining order, goes to court and gets a civil restraining order for a year. And for a period of a year, there's no new developments. In July of 2018, another statement. Essentially, you will never silence me. If you're at a public forum, I'm going to show up and maybe I'll bring a couple of my friends. That one we get at. That one we look at. But let me provide a bit of context. 3 years prior, when I was state's attorney in Chittenden County, an individual from the KKK was in town. And he was handing out flyers to join the Klan. And if he was out here handing out flyers to everybody that walked down the street and gave it to everybody, I'd defend his right to do that. I wouldn't like it, but I'd defend his right to do that. But in the Burlington case, the evidence demonstrated that there are only 2 people who received those flyers, who happened to be 2 women of color in the entirety of the south end of Burlington. We brought that charge. We won at the lower court. We lost at the Vermont Supreme Court. That it wasn't a threat. So you take that statement of, I'm going to come to a public forum and maybe I'll bring my friends, and you measure that up against, is it an explicit threat of harm? Is it a serious intention that would place a person in fear of death or serious bodily injury? And the legal answer that I came to was no. It would not. And then you look at the precedent of the First Amendment, and you look at different cases that have interpreted that exception to protected speech, which is, of course is that true threat. Protected speech, and then you have those exceptions, that true threat doctrine. One case was when candidate Obama was running for president in 2008, and you had another public domain message board, incredibly racist statements and something saying somebody deserves or he deserves a 50 cal to the head. The court said that was protected speech. Another case, in the state of Washington, Christine Gregoire was the governor. Another public domain message board threatened or wished sexual violence upon her daughter and said that she should burn at the stake like any heretic. The court said that was protected speech. That was political hyperbole. An incredibly high standard. And when you look at, well, what does constitute that true threat? It is that explicit case of, I'm going to kick you know what. The explicitness of it. And let me tell you, do I wish these facts were different? Of course I do. Of course I do. But I also know that if we're going to have credibility as the chief law enforcement officer, when I sue President Trump and say that you have violated the rule of law, then I need to apply that same standard here in Vermont to myself. And to call it like I see it, not by my personal likes or dislikes, not by my emotions, not by my political views, simply by the law. And when you follow that rule, the answer was clear in this case. It has sparked a great debate in this state, and I think we're having this debate in this country about political speech, about hate speech, and what it is. And people say, well, it's a hate crime. So let me tell you what the hate crime is in Vermont. Hate crime in Vermont is a sentence enhancer that you still have to prove an underlying crime. And then when you demonstrate and prove that it's been motivated by animus towards race or gender or religion, you get the enhancement. And folks have said to me, well, why don't we change the First Amendment? And I said, well, if we did that, that rally that you attended with 20 other thousand people in Montpelier as part of the Women's March was guarded and was protected by the First Amendment. This is not easy. This is not easy. And we are far from perfect on this issue, and we have a lot of work to do on the issue of race and a lot of work to do on the issue of hate. But suggesting that we change the First Amendment, I don't think, is the answer. You know, when something horrific happens in this state, and if it's a murder or any type of horrific crime, I'll tell you what the police are going to do. They're going to do everything they can not to violate that individual's Fourth Amendment right when they search him or his house. They do everything they can not to violate his Fifth Amendment right when they attempt to interrogate him. And then when he gets to court, I'm going to tell you what the judge is going to do. He's going to do everything he or she can not to violate his Sixth Amendment right. These are rules that have stood the test of time in a very imperfect way, but I think for the benefit of the majority of our country. Now, we can't get away from this issue of race, can we? And this issue of that reasonable person. Who is that reasonable person? Is it my experience? Do we take into account the historical legacy and trauma of the African American experience in this country, particularly with law enforcement and particularly with hate? That is the next debate. I'm open to it. I think it is a vehicle that's available within the law should the facts present themselves to push the envelope within the bounds of the law and our system. And people have said to me, well, Brown versus Board of Education, why don't you take this up and go all the way to the Supreme Court? We wouldn't have gotten past probable cause in this case. Dismissed at arraignment. No accountability. Then we're attacking the Vermont judiciary. Leadership requires some guts sometimes to do what's unpopular, to stand up and to make a decision and then to be held accountable to it, to answer your questions, to acknowledge your shortcomings, but to be steadfast in your position that you made it for the right reasons because it was the right legal decision. It wasn't the political decision. And when you look throughout our nation's history, I believe it's those decisions that have not chipped away at our constitutional rights, that have not put political convenience above the law, but have made these decisions that are based on the facts and the evidence and fidelity to our Constitution. This is not, we are in an incredibly challenging time. I know that. But this is not the time to walk away from our Constitution. This is the time to embrace it. This is the time to push the envelope in our system of law when the facts present itself. To make sure that when you have the case that can go up through the appellate courts and really affect change, that it's the right case. But to have the courage to call it when it's not. That's the struggle. I know I made an unpopular decision, but I know I made the right legal decision. I know I'm getting filmed and I probably shouldn't say this, but I'm going to say this. There have been times over the last 6 or 7 weeks where I've woke up early in the morning, because this one has weighed on me, and I've reread the facts. And I'm sure, Dean, you've had cases over your career where you've done the same. This is the thing you got to know about being lawyers, guys. It's a 24/7 job. The cases don't leave you when you leave the office. You'll be up at 3 in the morning thinking about this stuff. You get up, and you reread those facts, and I keep saying to myself, what I miss? What I miss? What I miss? I didn't miss anything on this one. And when you go and take that oath, remember that oath. Because it's not to do what is politically convenient. It's not to do what's going to score political points. It's a decision over that long arc in our nation's history. From a document close to 240 years ago. And those challenges that perhaps they didn't acknowledge, but we now do, is our challenge, in the words of Lincoln, to make a more perfect union. And you, in your careers, are going to be in the vanguard of that process, and I welcome you to the fight. Thanks for having me, and I have any questions.